deeper into this particular conversation and just try to understand what the courts, the responsibility of the Environment and Lands Court actually does. Take me back a little bit on, how the journey has been ever since its formation.
What happened is that before the 2010 Constitution, the court was not there. But the craving to have an Environment and Land Court was very much alive because land matters are emotive. The land governance issues had been with us for ages, like what we were talking in the first, when I arrived. Transitioning of rights from customary to individual ownership, rights of proprietorship. Things were not right because the laws which were there, particularly the legal regime governed by two particular statutes, that is Cap 300, that is the Registered Lands Act, and Cap 281, the Registration of Titles Act. Those were the two main statutes governing registration. They were so much into indefeasibility of a title, such that everyone was doing everything they can to get that document, that piece of document, that is a title. And in the process, a lot of corrupt schemes, irregular allocations, illegal allocations happened. So by the time we were getting the 2010 Constitution, it was clear that we needed a court that is dedicated to hear these disputes because there were very many, they were very complex, and they were very emotive. So that is how the court was formed. The statute that operationalized the court was the Environment and Land Court Act of 2011. It came after the Constitution. Then the court itself was operationalized thereafter in 2012, and the first 15 judges, 15 or 16 were posted, were appointed and posted in the country. You can imagine.
15 across the country?
Yes, in the entire country, 15 or 16. So you can imagine just that number for over 45 million Kenyans. It was just a very small number. In 2016, more were appointed, and I was in that lot of 2016. Oh,
you're in the lot of 2016?
Yes.
So that was the second lot?
The second lot, and now recently, last year, another group was appointed. So currently now we are 53 in number. 53? 53 judges in 40 counties.
All right.
53 judges in 40 counties.
40 counties? Yes. Meaning there are 7 counties that do not have that?
Yeah, there are 7 counties that do not have the ELC courts. That is what we call the court, the ELC.
Okay. So why don't you have ELC courts in those particular areas, the 7 counties?
We also look at things like the workload. Perhaps some of those courts do not have the workload, sufficient workload. But what we do is we set up what we call sub-registries, such that the nearest Environment and Land Court judge will be visiting that court periodically. Yes.
All right.
So it's not as if those counties are left
totally, left out.
Yes, they are not left out.
Which counties are we talking about?
I can say, for instance, in Marsabit, we don't have an ELC court. Tana River. Which other one? We have
quite a number.
Yeah, there are quite a number.
All
but
right.
you can see we have even places like Kilgoris. We have an ELC court.
Okay.
Voi, we set up the other day in the course of this year.
Okay.
So we are progressing well.
Okay, so the plans are underway still to set up courts in those particular areas.
Yes.
All right. In terms of what you call cases that has to do with land disputes and all that, and whatever the court handles, these areas, do they have a backlog of that? Are they quite a number of cases from these particular areas that do not have these courts?
I would not say that there is backlog, because if there were very many disputes in those particular areas, they would definitely post a judge there. So let me give an example of Marsabit. The cases in Marsabit are handled in Isiolo Environment and Land Court. So you will gauge the caseload in Isiolo because it will cover Marsabit.
Okay.
And you will see whether there is a need now to post a judge in that particular county.
Okay.
Yes.
We started with 15 or 16 thereabout
Yes.
when it comes to numbers of judges that are actually dealing with the Environment and Lands Court.
Yeah.
I'd like to assume or believe that at that particular moment, the issues to do with land were quite a number when it comes to, you know, just how many cases we were dealing with, you know, in a particular period of time, maybe a year or so. Right now, looking at then and when you were coming in as the second cohort, and this particular moment, what will be the difference when it comes to the cases that have been able to be handled?
I can say the difference is monumental. It's quite big. I may not have the statistics with me, but in year 2022, we held a conference similar to the one we are going to hold now. We held it at Kilifi.
Okay.
And what we were doing is to look back at what we had done, and the gauging that was done showed that the court had dealt with a lot of backlog, cleared so many cases, and that is documented.
Okay.
Yes.
All right.
Yes.
So in terms of you know, clearing the cases, just like you put it, that it has been very progressive, you would say that, in terms of the successes that we've been able to register as far as these you know, issues are concerned. What would you say has been the major challenge, you know, along the way?
The major challenge, one I would say, is that historically, those disputes concerning land and environment, they are very, very complex.
Okay.
So, whereas you would wish to rush a case and do it very fast, you can't rush a land matter. Okay. Because you need the facts, you need all the details. Sometimes you need maps which are illegible. You have to look for the people who made those maps. You need the experts. They are not there with you in court. You have to look for them. Okay. So the cases are very, very complex. So some are very voluminous. You may find a case of year 207, year 202, getting to know the history and ensuring that when you are adjudicating upon that particular dispute, you follow all the right steps. You get the proper evidence is availed. Okay. Even the way we dismiss cases, for land you take long before you dismiss a case. Okay. You have to ensure that you have used all means to ensure that that case has progressed to a logical conclusion. So that whole process is, I would say, it takes time. That's why the cases takes time. And then in land matters, what happens is that sometimes the incomplete processes, we deal with incomplete processes. For instance, somebody got allotment, allotment letters. You know, allotment is just a step to acquisition of the title. Okay. They got allotment in the 1990s, but they still don't have the lease, they don't have a title. But in between, other things have happened where the paper trails are concerned. Okay. So other people have acquired also another allotment. Somebody else also has a lease from the city council. And somebody else has a title from the ministry for the same particular piece of land. Okay. So the court is expected to unravel that mystery. Yet the court is manned by human beings. Yes. Where these documents are, you may not know. The people who are supposed to avail them, they may not even appear, or they are no longer there. So you see the difficulties. Yeah. So there are multiple titles, multiple allotments, multiple leases. For the one
in that particular case, how do you get to identify who exactly should get this particular land?
What we do is that we follow many factors. We go to the root of claim of ownership for each claimant. So if it's Mr. Amoy, your documents, you bring them. You have to give us the root of your title, or your claim. Maybe you just have an allotment. And the other one like that. So you gauge between all these four of them, who could be telling the truth.
So it has to, you have to gauge on the, you know, somebody that will be telling the truth, not based maybe on the evidence that they're actually getting to provide, because somebody could provide a title deed, yes, but the way they acquired it might not have been the right way. And for example, I got the, you know, the piece of land, what you say, the allotment in, you know, the year 2000. Somebody got a title deed in 2005. I'll believe that I was, you know, it was rightfully supposed to be mine since I was there the first person. So you gauge in terms of the evidence that we are going to provide, and also try to understand. So in this particular scenario, the person that got the first, you know, as was given allotment, or the person that has the title deed, who is likely to get this?
We do have that principle of jurisprudence. We say that the first in time is the correct one when there are two or more competing interests. But that is if on the face of it, all of them appear to be correct. All of them appear to have proper processes, issued regularly. So in that case, we use that jurisprudence of the first in time. But it doesn't follow that the first in time, that is the oldest, is the one which is correct. You may have that even the oldest and even the newest, and all of them, those claimants, none is the owner. We do have those scenarios. Yes. All of them are either fraudsters, or they got the land irregularly or illegally.
Okay, so the owner has not presented himself then, or herself?
It could be government land, it could be a private owner. And so it doesn't follow that the claimant, the people claiming, the ones before you, are the ones who are the owners. You find that in the process of adjudicating the dispute, at the end of it all, none of them is right. Okay. Yes. So, for instance, we have scenarios in places where the owners left the country, or I don't know where they went to. The claimants come and tell us the land is actually owned by somebody. They mention the name. We understand he left the country, and they are claiming that land. They are not claiming under the doctrine of adverse possession. They are just there. They want the land. They have been living there. So it's a very fluid, whatever situation, and it's for the court to unravel those mysteries and determine the dispute. Okay.
That brings me to somebody, there's a land somewhere. People have been living on that. The owner of that land might have disappeared, left the country, went abroad, you know, greener pastures and all that. Then comes back after 15 to 20 years, or let's say 30, and comes and finds that the people that now started living on that particular land, what we call some access quarters. Yes. They've been living there for 25 years. What happens in this particular case when now we say you're going to demolish your houses because this is not your land, this is my land?
I'm the one who had given that scenario of somebody who is not there. Absentee people, absentee land owners. So there is a global doctrine known as adverse possession. So if you stay on somebody's land, and that land is titled, and it is private land, and you stay on it continuously for a period of 12 years, you are entitled to that land through that doctrine known as adverse possession. So the owner must be knowing, he left, he knows that somebody is occupying his land. So the owner must be having knowledge that there are people on his land. So you yourself, you must be knowing that you don't own this land. But you fence it, you start building it, you start using it as if it's your own. Everything you do, it's as if you own that land. The 12 years have matured. You just come to court and apply for entitlement, and to be issued with a title, the owner's title to be cancelled, and for you to be issued with a title through that doctrine. Yes.
Is that okay? What if
it's not a Kenyan doctrine? Okay, it's a global one. Yes, doctrine. Yes. I think
does it not work, you know, to the disadvantage of the original landowner then?
I think the rationale is that land is valuable. If it has been lying there idle for 12 years, somebody may be needing it, not you, the owner.
What if these people have been living on my land? I'm unable to come back to the country, but I've been giving them notices when it comes to vacating, and you know, so immediately when I come back, then I want to make sure that they leave. Do they still get to you know, possess the land after the maturity of 12 years?
No. One of the criteria for that ownership is peaceful. It must be something peaceful.
Okay.
That there is no threat. You are doing it openly. You have not been threatened. So it is uninterrupted. But if it's somewhere where there is push and pull, you have been told to leave, there are a lot of eviction notices, you have been warned, the court may find that that is not a peaceful occupation. Okay. Yes.
Oh, so then the land will go back to the original owner?
It will not go back, it remains with the original owner. Still has the title.
Because it hasn't left the original owner. All right. So we are talking about some of the cases that are likely to come to your courts. What are these cases? What would you say are the most cases that you normally handle in terms of type?
Okay. It depends on the location or the region. For instance, the cases which are handled by the Environment and Land Court in Nairobi, they are not the same as the ones in Mombasa or in Kajiado or in Kilgoris. They are different because of what we had talked earlier, the categories of land and then the routes of entitlement. So you'll find that here in Nairobi, what you consider is, first of all, the tenure system. The tenure system is that bundle of rights and interest in land you hold. So you either have a title or a lease or an allotment, but you'll find that a place like in Nairobi, there are very many other people who, in fact, majority of people do not have titles, they don't have allotments, they don't have those leases. They are the majority here in Nairobi. What is it that they are holding? So they have plot letters, they have plot cards, they have these share certificates from land buying companies. So it's a strange, I can say it's a strange tenure system. But the court has to resolve those disputes. So, for example, most of Eastlands, there is that kind of a tenure system where it's just move into a big portion of land. They call them Mradi system. And they just divide the land. It may be through land buying companies, or it may be through invasions. It may be through land occupied by the land owned by the county council, either given or it's invaded upon. So those are disputes that you have to unravel, because the fact that they don't have a title or a lease or an allotment letter doesn't mean that they don't have disputes. They have the same disputes that the people who have titles have. You know, boundaries. They even have double allocations and multiple allocations. Then a place like, let's say Karen, that's why you have adverse possession, because you will see that the owners of the land, the Wazungus, they left the country. Some left the country. Some have aged, and people identify that's an old man or an old woman. They start, you know, knowing how to go about it. Some of the claims are strange because they are not proper. They know the person is just aging, and they bring those claims. Some are lawful claims.
You want to claim somebody's land because you feel like they are advancing in age, so that they might disappear, you know, God forbid, die. So that, and when that happens, that land will not have someone to...
Anything can happen, especially in Nairobi. You will find that somebody can identify you, an old person, or somebody who is, whose land can be taken through that doctrine. And they start processing, they start undertaking the process. They can come and file a case of adverse possession. When they are out and they get their orders, and the next thing you see somebody being evicted. We have seen it even on live TV. Others can be that it is not through adverse, but they just identify this, this is empty land. You know, they walk by. They can just walk by and identify empty land. They start the process of owning that land. They do the documentation process. And the next thing, they are the owners. All they do is move into the land, they start fencing, and they occupy. They can even, this is the level of fraud we deal with. They can even identify the land and it is occupied. But they still process the documents, they get the title or the proper documents, and the next thing you see, your gate is being knocked.
Yeah, we've seen that on TV.
When you are pulled out of your whatever, establishment, your home, you are thrown outside. So, you know, the first thing you call the police, or the police come, and the first thing you are asked is, where is the documentation? So you present your documents, you have the documents, and the next thing, the matter is in court, and this fraudster may be the one filing for an injunction, to get an injunction, and the court issues an order of status quo. So the status quo is the one who is inside. Mark you, the fraudster has gotten inside. So you can see the viciousness. So in Nairobi, the complexity, the fraud, the uncertainty of the tenure system, those are the major ones. So we deal with double allotments, multiple allotments, invasions, those adverse possessions, expiry of leases. If a lease is about to expire, somebody knows about it. They can go start processing it in advance. The next thing you know, and we have even seen it also in live TV, somebody is coming to evict you and you are wondering why. You are the one who has been holding this lease. But in places now like outer stations, for instance in Mombasa, you will find now the disputes are totally different. There we have the phenomenon of people who own the houses, but they don't own the titles.
You own the houses, but you don't own the title, meaning that land does not belong to you, or what?
The land does not belong to you.
But you build on that particular...
But you have built on that land because the owners left a long time ago. So houses without the titles. So that is a phenomenon at coast. The court still has to resolve those disputes.
All right. If
you go to places like Meru, the Rakanithi, there are places where now the customary land holding is ongoing to transition to individual private ownership.
All right.
If you go to places like Saburu, if you go to places like Masai land, we had the group ranches where the people owned land under the Group Ranch Act. It's a community kind of ownership, but now they have to transition to community land. Community land which has to be registered.
All right.
So you can see now their different kind of disputes are very different from what we have in Nairobi.
So the disputes are actually dependent on the location.
The location, the region. If you go to places like Nyeri and Muranga, there that issue of customary entitlement is very, very much active. Because what happened during after adjudication or during adjudication, the person who was the eldest male person in the family was the one who was registered as the owner of the land in a family setup. So he was meant to hold that land in trust for the other family members. I'd like you to hold that particular point because I need to take a break here. Then we come back and talk a little bit more on this particular issue that you are having this morning, and that has to be issue to do with land. Of course, we also get to touch on this conference that is coming this particular month, and issues to do with climate justice. Get to understand it is environment and lands court. Where does environment come in on this particular issue? Right, we take a break. We'll be back in a few.